Two, and that Nigeria has both the power and the capacity to punish anyone who, through deliberate, reckless acts of terrorism, seeks to divide the country by attempting to create the so-called Republic of Biafra by force out of the Federal Republic of Nigeria. My Lord, consequent upon the conviction, as nothing further remains but the lawful imposition of sentence, the punishment prescribed for the offenses in counts 1, 2, 4, 5, and 6 is death penalty. Pursuant to Section 1(2)(h) of the Terrorism Prevention Amendment Act 2013, my Lord, with all sense of humility, I say, sir, as a prosecutor, that this court has no discretion in that regard, and that the only sentence that your Lordship will impose for counts 1, 2, 4, 5, and 6 is death sentence. This court has the power to do so, and with respect must do so. The language of the act is clear, and the court is urged to apply it strictly without deviation. For the offense under count 3, relating to membership of IPOB, a proscribed terrorist organization, the punishment is imprisonment for a term of not less than 20 years, in accordance with Section 16(3) of the Terrorism Prevention Amendment Act 2013. We urge your Lordship, in accordance with death sentence, to also pronounce and impose the sentence as prescribed by law, having found him guilty and convicted. For the offense under count 7, the punishment is 5 years imprisonment without the option of a fine, pursuant to Section 46 and 47 of the Custom and Excise Management Act, Cap C 45 Laws of Federation. In sentencing, this honorable court is obliged to consider the nature and gravity of the acts of terrorism committed by the convict. It was against, the acts of terrorism were against innocent Nigerians who resides in the southeastern states. It is also a terrorism act against Nigeria, whereby nobody felt safe and secure in Nigeria, having regards to the activities of IPOB and ESN. The court is urged to note that the company has shown neither remorse nor penitence for the innocent Nigerians who died as a result of his directives and incitements. He has demonstrated no respect for the administration of justice. His conduct, even within the court, has been marked by arrogance and a heart far removed from humility. When he was going out, he looked at me and said, God will bless me. He won't say God will punish me. He said, God will bless me. And I say, amen. Because I'm a blessed man. It is not him, a convict, who can now put a curse on me. He cannot do that. So in any event, my Lord, I'm not being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitudes. The court is further urged to take judicial notice of the fact that the convict established Radio Biafra, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my Lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications live broadcasts, and social media communications constitute acts of incitement, encouragement, and provocation of terrorism as defined under the Act. It is the view of the prosecution board that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in southeastern states of Nigeria, including Lagos, would not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. Their amplified reach resulted in a coordinated transnational militarism or militarization of violence and destructions of public